morning. This is Isaiah Morris in the Judge Morris Court. We are here deciding if the gas can be used as evidence in the Sid Price case. All rise. State your position.
I'm Michaela Morris in defense position.
I'm Raylon Rutherford in prosecution position.
You may sit. Defense, you may proceed with your argument.
Good evening, Your Honor.
Good evening.
We request that you sustain the evidence being the gas can due to the fact that it violates the defendant's rights regarding the Fourth Amendment.
Proceed.
Thank you, Your Honor. With information on the Katz versus United States in 1967, FBI agents placed an electronic listening device outside of a public phone booth, so to hear the conversation between a defendant and another unidentified person. And during this conversation, the defendant transmitted gambling information in violation of the statute.
What does that have to do with Sid Price's case?
The evidence provided in this case are similar to that of Sid Price. The rights of said defendant were in fact violated. The defendant's car was unlawfully inspected and searched by Officer Jan Bernard.
Prosecution, you may state your argument.
Good morning, Your Honor.
Good morning.
Prosecution requests that you deny the defense's motion. May I proceed?
Proceed.
The search of Sid Price was constitutional under the Fourth Amendment. The search of Sid Price's vehicle was not pretextual, and the gas can was in plain view of Officer Jan Bernard. Prosecution argues that the detention of Sid Price was legal under the Fourth Amendment. Warren versus United States 517-806 in 1996, the defendant was stopped in a high drug area for suspicious activity. Officer seen in plain view 2 plastic bags of cocaine and was used against the defendant in a court of law. The detention of the motorist was legal under the Fourth Amendment because the officer came upon probable cause. It was a situation where a reasonable officer would have stopped the defendant. Your Honor, our case is very similar. May I proceed?
Proceed.
Defendant Sid Price was pulled over by Officer Jan Bernard because he also noticed suspicious behavior on Sid Price's vehicle, therefore giving probable cause and being able to temporarily detain Sid Price. Officer Bernard found an important piece of evidence against defendant Sid Price. So prosecution requests that you deny the defense's motion. Thank you.
Thank you. The defense may proceed with a counter-argument.
Your Honor, the argument presented by the prosecution is not a legitimate excuse for disregarding the rights of the defendant. In this case, the police officers pursued a car of youthful occupants who didn't move for an unusually long time, and then drove off in an unreasonable speed. This case lacks reason and relevance to the case of Sid Price. However, there are similar mistakes made by the said officers. They stopped them due to their peculiar driving, but they had pulled them over with the idea of inspecting them for drugs.
Thank you.
Katz versus United States 389, U.S. 347 in 1967, defendant's Fourth Amendment rights were violated because officers purposely put an electronic listening device on a private phone booth listening to a private conversation. Therefore, evidence was thrown out. Our situation is nothing like this. Therefore, because there was probable cause, suspicion, and evidence was in plain view. So the prosecution requests that you deny the defense's motion. Thank you.
Thank you.
Yeah.
I find for the defense because the arguments towards Sid Price's case were more